One of my subscribers has suggested I make a video talking about USA citizens applying for asylum in Canada. If you want to suggest topics for future videos, comment below or email me at zetesgrants@gmail.com. The first thing I want to mention is the Canada-US Safe Third Country Agreement. Any people from outside of US and Canada who travel through US to get to Canada are basically automatically denied asylum because this agreement states that they should have applied for USA asylum instead. If you are a US citizen, this doesn't apply. The website says it is usually not a barrier, but that's probably just covering their ass in case of unforeseen circumstances. Quote, your main challenge is proving the refugee legal test, especially why U.S. protection is not reasonably available to you and why you cannot safely and reasonably relocate within the U.S. End quote. As with most legal matters, a lot hinges on what is considered reasonable. Historically, there has been a very high bar for US citizens to clear in terms of convincing Canada that they should be accepted as a refugee or asylum seeker. For example, the recent news about anti-ICE protesters being arrested and convicted could lead some US citizens to fear for their safety, autonomy, and freedom of speech, freedom of religion, and so on. Hypothetically, if Alaska were to publicly offer sanctuary to leftist US citizens fleeing ICE, then Canada would be more likely to deny asylum seekers and redirect them to Alaska. On the other hand, if a state or city were to do that public declaration, and then the National Guard was called in to prevent this sanctuary, then that second action would count as further evidence to Canada that asylum is reasonable or necessary. Hypothetically, if a white power enthusiast sought asylum in Canada, they would likely be denied, since Canada doesn't have the same freedom of speech that the USA does, and said person would be less likely to be arrested in USA than in Canada. For lower stakes situations, like an abused youth fleeing their parents, Canada would most likely deny them asylum because there are so many places in USA that they could flee to. What if someone is being hunted by stalkers or the KKK or mafia or something like that? Well, if they come from Texas, they would have to travel through a whole bunch of states to get to Canada. So they would have to prove that they would still be in danger in all of those places, as well as any other states that are equivalent distance as the distance from Texas to Canada. Whereas, if the person being hunted was from Michigan, they might only need to prove that the surrounding states were dangerous, not the entire country. This is not legal advice. I am not a legal expert. This is speculation based on the Government of Canada websites linked in the description below. Let's take a break from the hypotheticals and go through the Canadian Charter of Rights and Freedoms. These are kind of like the US constitutional rights. If some USA right is being violated, but it is a right that Canadians don't have, then asylum would probably be denied on that basis. The first section of the Charter says that there are reasonable limits prescribed by law on these rights and freedoms. Keep that in mind. Quote, the rights and freedoms in the Charter are not absolute. They can be limited to protect other rights or important national values. End quote. Section 2 lays out some fundamental freedoms. Quote, A. Freedom of conscience and religion. B. Freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. C. Freedom of peaceful assembly. And D. Freedom of association. End quote. Again, these rights can be limited to prevent other crimes or even harm being done. Section 3 is specific to citizens, while I interpret the first two as applying to non-citizens as well as citizens. Quote, every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly and to be qualified for membership therein. End quote. Most immigrants have a long waiting period before they can be granted citizenship. The exact number of years may vary, but there are certainly situations where they are here but not allowed to vote yet. Section 4 and 5 are about, quote, legislative bodies, unquote, so we'll skip those. Section 6 is, quote, every citizen of Canada has the right to enter, remain in, and leave Canada, end quote. And, of course, there are exceptions, like prisoners don't have the right to leave Canada. Then there's a second part, quote, every citizen of Canada and every person who has the status of a permanent resident of Canada has the right, A, to move to and take up residence in any province, and B, to pursue the gaining of a livelihood in any province, end quote. Remember, immigrants aren't automatically considered permanent residents. There is an application process for that. And there are exceptions to this right, where certain provinces can deny work eligibility or social services as long as it isn't based on discrimination. For example, OHIP is the Ontario Health Insurance Program. If someone from Manitoba moves to Ontario, they would have to apply to get into OHIP. Section 7 states, quote, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice, end quote. Section 8, quote, everyone has the right to be secure against unreasonable search or seizure, end quote. Section 9, everyone has the right to not be arbitrarily detained or imprisoned, end quote. Theoretically, someone in prison in USA, if they could prove that they were a political prisoner and haven't violated any US or Canadian laws, then they might be granted asylum. Although I'm not clear on how they would get to Canada to start the application. And they might be denied based on extradition treaties if a USA court has already convicted them. The next few sections are about people's rights when they are arrested or imprisoned. Theoretically, a political prisoner could use these to prove their rights are being violated in USA. Section 10, quote, everyone has the right on arrest or detention, A, to be informed promptly of the reasons therefor, B, to retain and instruct counsel without delay, and to be informed of that right, and C, to have the validity of the detention determined by way of habeas corpus, and to be released if the detention is not lawful, end quote. Section 11, quote, any person charged with an offense has the right, A, to be informed without unreasonable delay of the specific offense, B, to be tried within a reasonable time, C, not to be compelled to be a witness in proceedings against that person in respect of the offense, D, to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal, E, not to be denied reasonable bail without just cause, F, except in the case of an offense under military law tried before a military tribunal to the benefit of trial by jury where the maximum punishment for the offense is imprisonment for 5 years or a more severe punishment. G, not to be found guilty on account of any act or omission unless at the time of the act or omission it constituted an offense under Canadian or international law or was criminal according to the general principles of law recognized by the community of nations. H, if finally acquitted of the offense, not to be tried for it again, and if finally found guilty and punished for the offense, not to be tried or punished for it again. And I. If found guilty of the offense, and if the punishment for the offense has been varied between the time of commission and the time of sentencing, to the benefit of the lesser punishment. End quote. Section 12. Quote, everyone has the right not to be subjected to any cruel and unusual treatment or punishment. End quote. Section 13. Quote, a witness who testifies in any proceedings has the right not to have any incriminating evidence so given used to incriminate that witness in any other proceedings, except in a prosecution for perjury or for the giving of contradictory evidence. End quote. Section 14. Quote, a party or witness in any proceedings who does not understand or speak the language in which the proceedings are conducted, or who is deaf, has the right to the assistance of an interpreter. End quote. Section 15. Quote, every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and, in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. End quote. And there's a subsection that says things intended to ameliorate disadvantaged people are still allowed. Sections 16 through 23 are about languages, so we'll skip those. Section 24 says you can go to court if your rights are violated. Section 25 is about Aboriginal rights and agreements with the government. Section 26 says the Charter does not deny any rights that are not mentioned. Section 27 says to interpret the Charter for, quote, the preservation and enhancement of the multicultural heritage of Canadians, end quote. Section 28 specifies that the Charter applies equally to male and female persons. Section 29 says that the Charter does not revoke any rights and privileges given to religious schools in the Canadian Constitution. Section 30 specifies that the Charter applies to the territories, not just the provinces. Section 31 specifies that the Charter doesn't extend any legislative powers. Section 32 confirms that the Charter applies to governments, not businesses or private individuals. Section 33, this one is a lot of legalese, so I'll read the explanation afterwards. 33, subsection 1. Parliament or the legislature of a province may expressly declare in an act of Parliament or the legislature, as the case may be, that the act or provision thereof shall operate notwithstanding a provision included in Section 2 or Sections 7 to 15 of this Charter. Operation of exception. Subsection 2. An act or a provision of an act in respect of which a declaration made under this section is in effect shall have such operation as it would have but for the provision of this Charter referred to in the declaration. 5-year limitation. Subsection 3. A declaration made under subsection 1 shall cease to have effect 5 years after it comes into force or on such earlier date as may be specified in the declaration. Reenactment. Subsection 4. Parliament or a legislature of a province may reenact a declaration made under subsection 1. 5-year limitation. Subsection 5. Subsection 3 applies in respect of a reenactment made under subsection 4. The purpose of Section 33 is to require a government that wishes to pass laws that limit charter rights to say clearly what it is doing and accept the political consequences. Section 33 is sometimes referred to as the Notwithstanding Clause. It gives Parliament and provincial and territorial legislatures limited power to pass laws that may limit certain charter rights, namely fundamental freedoms, legal and equality rights. They can only do this if they clearly state that a particular law is exempt from the Charter. An exemption from the Charter lasts a maximum of 5 years, but may be reenacted by Parliament or the legislature concerned. To date, provincial or territorial legislatures have rarely used this section. It has never been used by the federal Parliament. End quote. For reference, the page I am reading this from was last updated February 4th, 2026. Section 34 says that, quote, Part 1 of the Constitution Act 1982, unquote, is officially named the, quote, Canadian Charter of Rights and Freedoms, end quote. This refers to sections 1 through 33. Now, there is something else on this page from Part 7 of the Constitution Act 1982. Section 52, subsection 1. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. End quote. Okay, that was a doozy. A lot of legalese there. So let's summarize. Section 33 says the government can limit but not remove our rights from Section 2 and Sections 7 through 15. That includes freedom of religion, speech, peaceful assembly, freedom of association, life, liberty, security, unreasonable search and seizure, arbitrary arrest or detention, being told the reason for arrest, legal counsel, to be released if the reason for detention is unlawful, trial within a reasonable time, presumed innocent until proven guilty, no retrials after you are acquitted, cruel and unusual punishment, witness testimony not incriminating themselves, language and sign language interpreter during court, equality under the law of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Those are the rights that can be limited but not fully removed by any law for 5 years at a time. And said law can be renewed 5 years at a time indefinitely. Scary stuff. And Section 1 rights may also be limited by laws without the 5-year limitation. So, in my interpretation, a USA citizen applying for asylum or refugee status in Canada would have to prove that one or more of their rights have been violated for rights in the overlap between the Canadian Charter of Rights and Freedoms, sections 1, 2, 7 through 15, and the Constitution of the United States. And they would have to make sure that the nature of the violation doesn't fall within any of the current Canadian restrictions or limitations on the Section 1, 2, and 7 through 15 rights. Anything outside that overlap will likely be seen as an invalid reason. Again, this is not legal advice. Then they would have to prove further that there isn't any sanctuary place in USA that they could safely travel to which would protect those violated rights. If you like this video, please like, comment, and subscribe. I have new videos coming out every Saturday.